This is case number 2144698. This is Oakland Community College versus Cameron Hill. The matter is before the court on the issuance of a subpoena. Your appearance for Oakland Community, if you will, counsel.
Good morning, Your Honor. Andrew Cates, P78292, standing in for the attorney of record and representing Oakland Community College.
Thank you, counsel. Good morning to you. I'm looking for Cameron Hill or someone representing Ms. Hill. If you are Hill, I should say. If you are here, please say something. If you're on the Zoom anywhere. The matter is set for 9:30 a.m. this morning. It is 10 o'clock a.m. Counsel, you had any contact with the defendant in this matter regarding the subpoena?
I have not personally. There appeared to be a proof of service for the subpoena. Let's see here.
So I don't see the proof of service in the file, so if you could reflect on that for a moment. The last affidavit of service I have has to do with a written garnishment. But do you have something regarding the subpoena that you can point out, counsel?
Oh, here we are. It was delivered on 9/10/2022 at 1:49 p.m. by our process server, Albert Sharp.
All right, sir. All right, given the representations of counsel regarding the service in this matter, the court would make the finding now that the defendant has not appeared and has violated the call of the subpoena. Your pleasure at this time, counsel.
We would request an adjournment for about 3 weeks at this point.
Okay. Are you so you're going to reach out again to see if you can get this person in? Is that what it is?
Yes.
All right. All right. So at this point, then I'll go ahead and grant the adjournment at your request rather than issue a show cause. And we'll set it over and give you a new date, 3 days, 3 weeks hence. That date's going to be
October 12th.
10/12/22, and that's going to be at 9:30 a.m. Be the next action date. Subpoena be adjourned accordingly. Thank you, counsel. Good day.
Thank you, Your Honor.
The court now calls case number 22-183020. This is credit acceptance versus Talisha Ingram. The matter is before the court, set on for a first hearing, a status conference. Your appearance for credit acceptance, please.
Good morning, Your Honor. Andrew Cates, P78292, standing in for the attorney of record and representing Credit Acceptance Corporation.
All right, thank you, Mr. Cates, again. And let's see if we have counsel or someone representing Ms. Ingram. Ms. Ingram, if you're on this Zoom, or counsel for Ms. Ingram, say something at this time, please. All right, the record should reflect that I did. The court did receive an answer, a form answer to the complaint, and that answer was filed with the court on or about the 30th of June of 2022. Subsequent to that time, on July the 6th, the court did issue the notice of this particular conference with the correct Zoom address, and also directed to the address provided by Ms. Ingram on her answer. Let's see what's going on. And matter of fact, the answer reports an address on Cherry Lawn The address that was on the complaint. There were two addresses on the complaint. One was to Destiny Willis on Cherry Lawn. The other was to Felicia Pitfield on Ann Arbor, in Ann Arbor, I should indicate. The answer in this matter seems to relate to Miss Ingram. And Miss Ingram indicates her address is on Cherry Lawn Street. And she didn't get the notice of this hearing. The notice went to the address for Miss Willis. Hold on, let me just make sure. The notice went to the address in Ann Arbor, and this Miss Ingram's address seems to be an address on Cherry Lawn in Detroit. So I think I got to renotice this one, Council.
Very well, Your Honor.
Yeah, we have both addresses in the court's register of action, but the notice of hearing only went to Miss Ingram at the Ann Arbor address. Let's see, they got it right. Hold on one second. I had a little bit. So when the complaint was filed, the complaint listed Miss Ingram's address on Pitfield and Boulevard in Ann Arbor. When Miss Ingram filed her answer, she listed the address on Cherry Lawn as her address. We were served on Cherry Lawn, that is Miss Ingram. And when we sent the notice, we sent it to Pittsfield and Ann Arbor. So we got to renotice this. Madam Clerk, if you will, give me another date for the status conference, 2 or 3 weeks out. Just
October 12th.
October 12th, Council, same day you're coming back. We're going to go ahead and do another mailing of the status conference date to the address on Cherry Lawn in Detroit. Even though that address seemed to have been tethered to Miss Willis, the address, the document or the answer that was sent in by Ms. Ingram, that answer is tethered to Cherry Lawn. So we're gonna send a notice to both addresses and October 12th, and that's going to be at 9:45. October 12th, 9:45 a.m. Thank you, Council.
Thank you, Your Honor. Have a good morning.
All right, you too. The court now calls case number 22-185-143. This is Progressive Michigan Insurance Company versus Nanetta Thomas. The matter is before the court, set on for review. The court did set the matter previously for a status conference, and there were some discussions, and the court then set the matter over for it to be reviewed on today's date. For Progressive Insurance, your appearance at this time.
Good morning, Your Honor. Tiffany Williams on behalf of plaintiff, P number 74809.
Thank you, Ms. Williams. Good morning to you, ma'am. I'm looking now for Nanetta Thomas. If you're on the Zoom or you have counsel on the Zoom, please say something at this time. Nanetta Thomas. All right, counsel, update me regarding this matter. I adjourned it for some reason. Go right ahead and talk to me.
Yes, Your Honor. So when we appeared last time, Ms. Thomas appeared via phone and also with her husband. They indicated that they were insured at the time of the accident. So we adjourned it to investigate that. We have confirmed that they were insured at the time of the accident. So the only thing that we're waiting for now is to see if the insurance company is going to cover the mini tort payments. I did speak directly to the adjuster So as long as they have that coverage in our policy, we will be dismissing it as it relates to them. If they do not, then it looks like we'll be settling it based on the discussions I had with Mr. Thomas for the mini tort amount. And in this case, the deductible is $500. That could be why they're not here, that they may think, since I did let them know that I spoke to their insurance company, that I've confirmed coverage, but obviously I didn't represent, they shouldn't appear today. But maybe they just misunderstood that.
All right, so maybe I should set it over for 3 weeks. Is that enough time to review it?
Your Honor, if we could do 30 days, because I'm not sure how long it's going to take the adjuster to process the mini tort claim. We've sent over the documents. I'm just not sure how long it takes for them to process it and get the check to us.
Got it. All right, so let me go ahead and set a control date about 30 days ahead.
October the 20th.
That's gonna put us at 10/20.
Thank you.
22, and that's gonna be at 9:30 a.m. 10/20, 9:30 a.m.
Thank you, Your Honor. We should have closing documents to you by then.
Thank you, Counsel. I appreciate it.
Take care.
Just one moment, everyone. All right, the court now calls case number 11-107602. This is BLG and Associates versus Shayna Robinson. Now, the matter is before the court on a petition to set aside a default judgment in this matter. Your appearance for BLG at this time.
Good morning, Your Honor. Christopher Sosson, spelled SOSSONGP 59383, appearing on behalf of the plaintiff.
Thank you, Mr. Sosson. Good morning to you, sir.
Thank you.
For the defendant Robinson in this matter, your appearance, counsel.
Good morning, Your Honor. Sam Jarbo, PA 454 for the matter.
All right, thank you, Mr. Jarbo. Mr. Jarbo, you brought a motion to set aside a default, and of course, this case is 110 years old. Actually, 10 years old. So tell me why you think this should be set aside, sir.
So I know the case is old, Your Honor. However, it's a client that came into my office and very emotional about what happened. And so here's what our argument is. Obviously, this action was filed in April 6th of 2011. And it is my client's understanding that she never received a copy of the complaint. She was never properly served. The defendant only learned about this action by the court notifying the defendant of a writ of garnishment that was given to her workplace, and currently at Macy's. That happened. She kind of freaked out. I think tried filing a motion to set aside on her own. That was unsuccessful, and then she retained my office to file a motion to set aside. The good cause is she was never served, and the meritorious defense to the case would be that she never opened up a Chase MasterCard. I'm sorry, she never had a Chase MasterCard. She had never had a Capital One MasterCard. When she spoke to DLG and Associates, or the creditor rather, they told her that it was for either a Chase MasterCard or a Capital One MasterCard, and she told them that she never had either of those cards, and so she believes that obviously this wasn't her. She's not the right defendant, and that the judgment should be set aside and her wages should stop being garnished, and that's where I rest my case, Your Honor.
Thank you, counsel, Mr. Sosson.
Thank you, Your Honor. As counsel indicated, yes, Your Honor, the defendant did previously file a motion to set aside the default judgment entered in this case. And by order dated June 8th, 2022, the court denied that. The court indicated in its order that the motion was denied as untimely, where the judgment was entered by default in the matter on October 18th of 2011 and renewed on August 17th of 2021. The court stated in its order that the petitioner never moved to set the default aside despite numerous collection efforts. And even though petitioner's address has remained the same, the petitioner has failed to show good cause for her failure to respond to the complaint and has not provided an affidavit of meritorious defense of the complaint. The defendant's already had a crack at this, Your Honor. And then just going back, as the court indicated, the judgment in this case was entered on October 18th of 2011 in the amount of $2,118.53. Over a decade later, the defendant is now seeking to attack the judgment, the underlying issue of liability. Clearly, Your Honor, over a decade having lapsed, the defendant's motion is untimely. And this second and subsequent motion, after the court already ruled on her previous motion, is improper, it's baseless. And we would ask the court to not only deny this second motion to set aside the default judgment, we'd ask the court to consider costs and sanctions as well, since already entertained her previous motion to set aside the default judgment. Thank you, Your Honor.
Your Honor, may I rebut?
Yeah, absolutely. No.
Your Honor, the reason that I understand that she filed the motion to set aside, but she didn't do it right. And she came and she just wanted a proper chance at this. And I told her that I would, help her. I told her it was an uphill battle. I told her we had a steep hill to climb. But, as far as sanctions goes, Your Honor, the court was clear in its order. It said that, she failed to provide an affidavit of meritorious defense. She failed to file right. So I told her, I said, we can take a stab at it the right way and try, and whatever your honorable court decides, as far as, the merits of the motion is one thing. As far as sanctions goes, this is just a defendant that wanted her. Sorry, I don't know why I cut out there, but this is just a defendant that wanted her day in court. So that's why the motion was brought, Your Honor.
Well, I'm not at all persuaded under these circumstances that a sanction would be in order, no matter what the determination of the court may be on the underlying issues. It seems to me that the challenge here is certainly delay, and the challenge of having received several notifications relative to there being a judgment in place, and then delaying even with that appearing. There have been multiple attempts at collecting on this judgment over the years, and then the original pleading, or I should say, the filings in the beginning indicated that there was an affidavit of personal service that was filed with the court on the 9th of August of 2011. There have been multiple subpoenas in 2012. A number of things that have happened over so many years. It would take an extraordinary act that would have to ignore all of the court rules and the statutes in such cases in order for the court to find a way back to this. If this was a situation where the plaintiff sat on their hands after having received a judgment and never took any action, that would be a much closer situation where the court had to look at it and says, well, they got a judgment, they never did anything or attempted to do anything. Maybe she was unaware that there was a judgment out there. But there have been multiple attempts over several years to collect on this. Now, 11 years later, I received this second motion. Although the second motion appears to be a lot more professional and well stated, it sounds in the same issues that were raised in the first motion, and without there being what I think could accompany this motion in some way would be if there was a history of some type of identity theft that could establish by a paper trail together with an affidavit, then that might be something that would have provided some level of review by the court, but I don't see anything to review here. I don't think that, and I'll be real honest, I don't think that the defendant in this situation is being litigious of just throwing paper at the court. I think that the defendant is trying to bring before the court an issue that she sincerely believes to be true, but her sincere belief in the truth of her position does not get rid of the fact that that this case has a history that does not justify the court taking action to set aside the default at this time. For the reasons that set forth on this record, I will deny the motion to set aside the default judgment injured in this matter.
Thank you, Your Honor. You have a great day.
All right, thank you, counsel. Good day to you.
Thank you, Your Honor. Thank you, counsel.
Thank you, counsel.
Rest with sanctions did not.
Thank you.
This is case number 22, 178867. This is Danita McCaskill versus Carlton Bowens. The matter is before the court. Looks like set on for a hearing. And it looks like it's been set on for multiple hearings somewhat recently. All right. Oh, yeah, I remember this case. Now, I don't have the big fat file with me. But I do recall that this matter was up in front of me, I think, somewhat recently. All right, your appearance for plaintiff in this matter, if you will.
H. Russell Smith, appearing on behalf of the plaintiff, Danita McCaskill.
All right, thank you, Mr. Smith, and good morning to you. Your P number, if you will, for the record.
P35922.
All right, thank you, and your appearance for the defendant in this matter, counsel.
Good morning, Your Honor. May it please His Honorable Court, Lance Mason, P43926, appearing on behalf of two of the defendants, the Rights of Gratiot, LLC, and the individually named defendant, my client, Mr. Donnie Wright. And this was it's an adjourned status conference, Your Honor, with all due respect.
All right, thank you. All right, I don't have the complete file here, and that's a part of the problem here. So I'm just getting to the document now, Mr. Smith. I'm just getting to the document that points out the very defendants that are in this matter. So I have a complaint that is against the Rights of Gratiot LLC, Platinum Ducts LLC, Boykin Heating and Cooling, Donnie Wright, Carlton Bowens, and Jeff White. So, and I know that Mr. Smith represents Ms. McCaskill, and counsel, you represent which defendants in this matter, sir?
I represent Mr. Donnie Wright as well as the Rights of Gratiot, LLC.
Gotcha. All right, do I have another counsel regarding this matter of McCaskill versus Rights of Gratiot et al.?
Your Honor, I'm here on behalf of Boykin Heating and Cooling and Carlton Bowens.
All right, got you. Your appearance, please.
Roman Fitzai, P47879.
All right, thank you, counsel. Good morning good morning to each of you. All right, I thought I had this in front of me before, but I was mixing this up with another case. So looks like this is the first time that there was an appearance here in front of this court. Somebody update me. What's the status of things? Maybe Mr. Smith, where are we at this juncture, sir?
Yes, Your Honor. Yeah, this is our first appearance. The other ones have been adjourned a couple of times. So we're just, I did ask both counsel if I could perform discovery. I did get consent from Mr. Mason. I did not take any other action with that. I don't know. I haven't communicated with how do you, Mr. Fitzai? How do you
It's
pronounce
Fitzai. It's Fitzai.
I apologize.
Just like it appears.
So I think, you know, I'm not sure what their defenses are. So that's where I am. I just want to get an idea of that going forth.
Well, we've supplied counsel with the affirmative defenses. We certainly don't have an objection to entering into an order for discovery at this point. I would say 60 to 90 days.
It's my understanding, Judge, just to chime in, that I don't even know if all the individually named defendants have been served. So I would agree with Mr. Fasai that we respectfully a 90-day discovery, at least we can get some activity to see where the allegations are going with respect to this complaint.
All right, well, it does, I love the 60-day discovery order, but 90 days may serve the party's interest a little bit more, because it seems like there is some pathway that's got to be traveled in this case here. All right, so I will set it on a 90-day discovery order. We're going to give you a specific date. I'll return. That date is going to be in December.
December
That's
5th.
December 10th,
5th.
5th.
Mhm.
All right, that's going to be 12/5/22, and I'm going to set that at 9:45 a.m. on that date. You'll receive an order for discovery concluding on that date. You'll have over discovery through that time. Also, as a part of my order, I'll point you to paragraph number 6. Paragraph number 6 allows you to file motions dispositive or otherwise, and to have the motion heard on the date of the pretrial conference. That's the 5th of April, where is that coming from? The 5th of December, my birthday month, the 5th of December at 9:45 a.m. So the only requirement is that if you file a motion and you want it heard on that date, make sure that the other parties have at least 10 days notice of the motion. Notwithstanding what the rules are in summary disposition motions, other forms of motions, if you file a motion in front of this court on this schedule, all you need to do is give at least 10 days notice to the opposing party, and I will hear the motion on the motion hearing date. Now, my order will not preclude the filing of motions in the future. This is just to give the attorneys the opportunity that if along the pathway you discover that there is something that you wish to have a hearing on, or you discovered something that should make the case dispositive, then you will not need to wait until you get to the pretrial conference to say, Judge, I'm going to file a motion on this. If you see it early enough and you want it to be heard, go ahead and file it and set it for that date. That's your motion hearing date. That's not excluding dates I might set in the future. That's a motion hearing date. The only requirement is that you give the other party, the opposing party, at least 10 days notice that you want that heard on the 5th, and I'll hear it.
Judge, I have one issue with the December 5th date. I'm scheduled to be in trial in Livingston County Circuit Court that morning. So I'm wondering if we get a different date, perhaps later in the week or the following Monday.
December 12th.
December 12th. All right.
Yeah, that'll
We'll
work.
adjust it to December
Very good.
12th, 2022. That time will stay the same, 9:45. That extends the discovery till that date, through that date as well. So discovery cutoff is the end of business day on the 12th. And you'll get this in a written order from the court. It'll be sent out today.
Very good.
Judge,
Thank
can
you,
I get Mr. Fitzsize P number again, please?
Yeah, yes, 47879.
Thank you.
I like how well you pronounce his name, because he says it's just as it's spelled, but you nailed it. The rest of us look at it and say.
She's familiar with it. She's familiar
Right,
with it.
exactly.
All right. All the best. Good to see each of you, and I'll see you on the 12th of December, if not before that date. All the best.
Very good. Thank you, Judge. Good to see you. Have a good day.
Thank you, Judge.
Very good. Thank you, Judge. Good to see you.
Great
Have a
day,
good day.
counsel. Thanks. Mhm.
All right, the court now calls case number 22-188-048. This is
Oh, we did it.
Credit Acceptance Corporation versus Jardine Jenkins. The matters before the court set on for status conference on today's date. This is the first hearing regarding this matter. Your appearance, counsel.
Good morning, Judge Coleman, Cezanne Barda, P65425 on behalf of Credit Acceptance Corporation.
All right, thank you, counsel, and good morning to you, sir. Do I have Ms. Charday Mitchell Jenkins, I'm sorry, on the Zoom?
Yes,
All right, good morning to you, ma'am.
good morning.
I did receive what I somewhat treated as an answer in this case. It was your letter to whom it may concern, and that triggered me to set this up for a hearing on this date. It seems that you're
Okay,
you pointed out that you filed a petition in bankruptcy regarding this case. Is that correct, ma'am?
yes.
So were you granted a discharge?
What ended up happening was I was discharged because I had stopped working.
Your Honor, just to clarify, she means dismissed.
I'm sorry, yes, I'm sorry, dismissed.
Well, yeah, that's where I was getting to. Yeah, if it was dismissed, that of course means that the bankruptcy court did not release you from this debt because they dismissed the case. You would have to
Okay,
actually have a discharge in order to avoid liability on the debt. All right, just one moment. Let me look at. And then the other thing that you point out is that at the present time that you're not collectible and that you are receiving some form of public assistance at this time. Is that correct?
yes, I am, Your Honor. I'm also pregnant again, and I am 8.5 months pregnant. My due date is originally November 2nd, but I have to have a C-section. So me and my doctor, I go back to the doctor on the 28th. So it's probably gonna be the end of October.
All right, Mr. Barter, it doesn't appear to really be an answer, but basically it seems that the defendant is pleading that, you know, she was trying to bankrupt or to take this to bankruptcy, and that she has an inability to pay, which is not an issue at this point. But, anything you wanted to bring to my attention?
No, not at this time, Your Honor. I believe we'll probably be filing a motion for summary disposition to get before you. I'm going to make sure I would ask for two things. One, if you're opening up discovery, which I don't believe is necessary, and setting it for another date, you should probably put it out as long as possible if the defendant is going to have a child at the end of October, early November. I'm also going to notate the file that if we do move forward with a motion for summary disposition, not to get a date anywhere near that end of October, early November date. So I foresee probably will be before you on a motion for summary disposition sometime in mid-December, early January.
All right, so what's being set up here, ma'am, is it seems like at least from the things that you told me in your letter, it doesn't seem that you have a defense really to the case that's being brought against you. And I mean, if you could have completed a bankruptcy, that would have been the way to go, but I understand it just didn't happen. But it doesn't seem that you raised any other defense here. So the plaintiff is going to file a motion and ask the court to enter a judgment. And as it relates to that, if the court enters that judgment, then what will happen is that they will try to collect on that judgment. And you have the right to file a petition to ask the court to allow you to make payments based upon the resources, et cetera. So all of that comes next. But right now, it's just a question of liability. So what I'm going to do is I'm going to go ahead and adjourn the matter, setting it up for a pretrial conference. And I'm going to set that in December. So that Mr. Barter can file a motion. If he wishes to file a motion, I will review the case at that time and make a decision as to what happens, whether or not a judgment should be entered based upon the complaint. Like I said, if a judgment is entered, all the other stuff comes after.
Okay.
If you could still, if you talk to a lawyer and they want to go forward, or you have a way to do it, if you believe that you have the right to file a petition for bankruptcy, or you could still file bankruptcy even after a judgment, whatever, if that's the approach that you want to take. Nothing about whatever happens here prevents you from being able to do that. You have the right under the bankruptcy code to proceed in these kind of matters, if that's what you choose to do. But I will look at it again in December. So that date in December is going to be
December 15th.
December 15th, 2022. We'll send out a notice with that date. It will be a motion hearing pre-trial. Motion hearing and pre-trial date. So 12/15/2022, and that's going to be at 9:45 a.m.
Can I also say something, Your Honor?
Yes, ma'am. Go right ahead.
Far as what vehicle, that vehicle, as I was in chapter 13 bankruptcy, we surrendered that vehicle. So I would really like to, as they doing their discovery, see they went and got and sold the vehicle, because they're asking the same price that was entered, was settled first with the bankruptcy part. When we started the bankruptcy, and my lawyer, he's retired now, but the bankruptcy lawyer, they settled 5,000, if I'm not mistaken, the amount that they're asking for, which I understand, like you said, it was dismissed, so it wasn't discharged, but we surrendered the vehicle. So I'm trying to see, did they sell the vehicle, or what happened with the vehicle, because we surrendered that vehicle at the time. I will try to get as much information as I can when it comes before the 15th, if I can. Like I say, I'm pregnant, so it's really hard for me to do a lot of things, but I will try to get as much information that I can to see exactly what date it was that it was surrendered on.
I will order that that the plaintiff in this matter provides you with any documentation they may have regarding the disposition of this vehicle. In other words, the vehicle is surrendered, sold at auction, any paperwork that shows what happened to this vehicle. I'm going to order that they send that to you within the next 30 days. So whatever.
Thank you.
Whatever possession in that regard, they'll send it to you.
Thank you.
Mr. Barr, you got that?
Real quickly, Your Honor, just to clarify, in her answer, she states that the car was stolen. Is that true, ma'am?
The car did get stolen, and once it got stolen, they recovered the car. The police station sent us, my lawyer, a letter saying they recovered the car. My lawyer called credit acceptance and said, hey, the car has been found. We are surrendering this vehicle.
Do you know?
They were supposed to give him an answer back.
Do you know what the condition of the car was?
No, I do not, because at that time, I didn't have a way to even to see the vehicle. They had happened to send me a letter after I went up there and 1,000 times at the police station, and they sent the letter to the house. And once they sent it, I called my lawyer at the time. His name was Mark McLaughlin. I called him at the time. He said he was going to get on it. He called me. He said, I talked to credit acceptance. I let them know we surrendered the car. Somebody told them that they was going to come and get it. Now, again, my lawyer is retired, so I have no way of getting in touch with him. But as I just stated, if any documents I can try to get myself, maybe at the office he's at, I can call that he was at, and maybe his clerk, if she still works there, I can try to get that information for you as well. But I do remember him calling me saying he talked to credit acceptance, and they said, okay, they was gonna go and get the car.
Yeah, any information you can get will be helpful, because credit acceptance never got that vehicle. So that vehicle was never retrieved. I don't know that, if it was stolen, a lot of times stolen cars get ransacked. So they could have gone there and said, you know what, we don't want this vehicle, it's worthless. Sometimes impound fees are so much that they decide not to take it. I'll try to find out more from my end, but they never got the vehicle, never sold the vehicle. this is just a deficiency balance on this loan that was not paid back. So any information you can get will be helpful.
So I'll
Okay.
I'll order mutually that the parties share any information they have regarding those kind of matters of what the disposition of the vehicle. So ma'am, if you get some information, you would make sure that you send copies of that to Mr. Barter's office. If he has a history of the disposition of the vehicle, and he's to send that to you as soon as he gets that in his control. This was an important question to come up. So I'm glad that you raised it, Mr. Jenkins, so that both sides can look at this towards the next date that you come back to court. Okay, so I do wish you well. A good day to both sides.
Thank you.
Thank you.